I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the final lawcast in a series discussing Rule 506 of Regulation D, including the difference between a traditional Rule 506B offering and a 506C offering that allows for general solicitation and advertising. To wrap up my series on this topic, I will hit on a few final points regarding Rule 506 offerings. Both Rule 506B and 506C are deemed federally covered securities and therefore preempt state law. Like any offering that preempts state law, the states can still require a notice filing, and the offering is still subject to the state anti-fraud provisions and can be investigated for violations of those provisions. Both offerings require the filing of a Form D within 15 days of the first sale. When 506C was enacted, Form D was amended to include, among other things, a new check the box for 506C offerings. At that time, there were proposals to require an advance Form D filing, but those proposals never came to fruition. Also, at the time of the Rule 506C rule changes, there was a great deal of debate regarding whether hedge funds should be allowed to rely on the rule and solicit and advertise. Ultimately, the rule does allow hedge funds to rely on Rule 506C, though the SEC has noted that it is monitoring the use by hedge funds, and it could change the rule in the future if it finds that there's been abuse. The SEC made a specific point of reminding hedge funds of the anti-fraud provisions of the Investment Advisors Act, which parallel the provisions in the Securities Act and are a good reminder for everyone. In particular, it is a fraudulent, deceptive, and manipulative act for an advisor or anyone to make any untrue statement of a material fact or to omit to state a material fact necessary to make the statements made in light of all the facts and circumstances under which those statements are made, not misleading to any investor or prospective investor in the pooled fund if it's a hedge fund, or in any offering if it's a regular offering, or otherwise, it's also fraudulent to otherwise engage in any act, practice, or course of business that is fraudulent, deceptive, or manipulative with respect to any investor or prospective investor, or with respect to the sale of securities. And that's an overriding theme for all anti-fraud provisions, whether it's under the Securities Act, the Investment Advisors Act, and there is also parallel provisions in the 34 Act. Finally, one of the requirements for a valid Regulation S offering is that there be no directed selling efforts in the U.S. Accordingly, many practitioners were concerned that Rule 506C would eliminate the ability to conduct a concurrent Regulation S offering, since 506C has directed selling efforts in the U.S. The SEC dispelled these concerns by specifically pointing out that Regulation S, by its terms, does not integrate with either a registered or exempted domestic offering. Okay? Since general solicitation under Rule 506C would satisfy the requirements of a U.S. exemption, the SEC will not view concurrent offerings under Rule 506C and Regulation S as integrating, such as to destroy the Reg S exemption. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.